I want to take to these non-mainstream advisors you talk about. I've had a bit to do with them, found one pretty good and others not so good. Did you have any involvement with former Senator Cullerton?
Yes, I did.
Could you tell the committee what sort of involvement you had with him? Who was the client?
I had involvement with Senator Cullerton in relation to clients of a bank called Mr and Mrs Bradshaw.
Right.
I can say that my involvement with former Senator Cullerton is that, in my view, he did not assist in facilitating discussions between the bank and its customers.
Why do you say that?
I say that because, for a number of reasons. Firstly, over a reasonable period of time, on a number of occasions, he would be contacting either myself, the receivers appointed, or the bank, saying that he would propose proposals to the bank to resolve the matter. Those proposals were never provided.
Over what period of time, roughly?
I would say, I'd have to check my file, but I would say that it was at least over a 6-month period, if not longer.
So 6 months, Mr Cullerton said he'd provide you a resolution, a proposal or whatever, and it was never forthcoming.
That's correct. Another reason is that over that period of time, on numerous occasions, Senator Cullerton would be threatening to file proceedings. Those proceedings were never filed, save for one instance where he attempted to file proceedings in the Federal Court in Sydney. The Federal Court in Sydney would not accept the filing of those proceedings, as they determined that they were vexatious and frivolous.
Were they ever filed?
No, the court rejected them for filing, so they never actually got through the registry.
So Mr Cullerton did go to court?
He attempted to file a document, which was a claim.
Yeah.
The registry of the court did not accept that document for filing under the relevant federal court rules, because they determined, the registrar of the court determined, that those proposed proceedings were vexatious and frivolous.
So it didn't get past base one?
Didn't get past base one is the colloquial way of putting it, Senator.
Did Mr Cullerton explain to the committee how Mr Cullerton actually damaged the Bradshaws from getting some sort of resolution, can you?
I would answer that question by saying, referring to my previous answers about the lack of proposals, the threats and attempts to file proceedings, and I would also say that the lines of communication between the parties, the bank and its borrowers directly, broke down. And I would also... Just
on that very issue, did Mr Cullerton say all correspondence, communication, etc. about the Bradshaws must be directed through him?
He sent a document which had authority from the Bradshaws for the bank and myself as its legal advisor to discuss matters directly with him. And I would also say that the other way in which, unfortunately, the involvement of former Senator Cullerton made the matter more protracted and difficult was that there was correspondence emanating from his Senate office, which...
it's from the Senate office?
From his office.
As the Senator?
As the Senator.
Yeah.
Which didn't seem appropriate to his office. It
okay,
said that...
You're under parliamentary privilege.
Yeah.
You're not going to get sued. Can you just
that's
give us
right.
a better layman's vision?
So
explanation.
So correspondence which suggested that validly obtained court orders were not valid, and that the courts who granted those orders did not have status to grant those orders, and that the particular bank customer in this case could disregard those orders.
And that all ended up to be wrong, of course.
That's correct, Senator.
Have you had any dealings with any other non-mainstream advisors?
Over time, yes.
Such as who?
Unhappy Bankers.
Geoff Shannon of Unhappy Bankers.
How did things end up with Mr Shannon?
Again, my experience is that he was running interference and not concentrating on the issues.
And if I can just expand on what Scott has said, is similarly my interaction with non-mainstream advisors is that they advise their clients to take certain steps which don't see a positive resolution in terms of a win-win for the customer, for themselves and the bank.
Ms Forrest, is one of those steps to go to FOS for a delaying tactic?
That has been, and that is not just in the this industry, it's across all industries. Some of the other examples would be the use of what is called a promissory note. And there's also, I've seen on a number of cases, references to what is called a QSIP number, which is a number out of America in terms of securitisation.
Well, there are probably only a half a dozen of these non-stream advisors, Mr Cooper, in Australia, wouldn't there be?
I couldn't put a number on it, but in terms of my experience dealing with non-mainstream advisors, I would say there would be at least half a dozen. In the cases of our interactions with
Should
them.
there be some regulations on them? And I say that because surely this Parliament's not going to regulate for 6 people in Australia, but what's the solution? If these people, see, these people come along the way I see it to the farmer, the people in financial trouble, and they seem to be seen as the Lord Almighty Saviour for them. And these people in a desperate situation, so they put faith in some of these people like Mr Cullerton or Mr Shannon, then it all turns to tears. What do we as legislators and regulators have to do, in your opinion, to see that this has a high standard level where people just don't say, oh look, you're here to save me, thank you very much, then they find out later that the non-mainstream advisor has little knowledge of the law, going on some constitutional thing of whatever, and of course it all ends up in tears. What are we going to do as regulators to fix it? And I don't want to go regulating laws for 6 people.
I agree, you can't regulate for everybody, but what I think you can do is to increase the funding and availability to mainstream advisors. So, for example, in Queensland, we have farm finance counsellors. Unfortunately, over the last few years, the number of farm finance counsellors available has reduced because of funding, both at a state and a federal level, to the extent that, as I understand it, because the number of state-based farm finance counsellors have reduced, there was an increased requirement for the federal-based farm finance counsellors to take up the slack. So the first thing that I would suggest the committee look at is to look at increasing the funding and the availability of farm finance counsellors, which is a free service to farmers in need.
The rural counsellors, basically.
Correct.
Okay.
The second thing I would say is I'd refer the committee to the submission of Dennis McMahon of the Queensland Legal Aid Service. What Mr McMahon said in his submission was that his role is limited in the sense that he can negotiate with the banks on behalf of farmers prior to farm debt mediation, appear for them during farm debt mediation, and negotiate after farm debt mediation if, for example, any agreements reached needed to be extended for whatever reason. What Mr McMahon acknowledged was that he couldn't, for example, represent farmers in court. Perhaps what the committee could look at is extending the funding and extending the role of someone like Mr McMahon. He's a Queensland-based legal aid, that's a state-based system, but there's no reason why this committee couldn't look at that.
Well, in my experience, getting legal aid for civil matters seems to be pretty difficult. Criminal matters, of course, someone gets represented in the courtroom under criminal charges, what I see. If they don't have any money, legal aid seems to be forthcoming, but in civil matters it seems to be very scarce. Is that a correct assessment, what I've said?
Generally, it's a correct assessment, but in respect of Mr McMahon and the service that he and another solicitor within Legal Aid Queensland provide, that is a free service to the farming community. And as I understand it, and this is perhaps a question for Mr McMahon, but as I understand it, it is available to anyone within the agribusiness community who can't otherwise afford legal representation.